Welcome back, ladies and gentlemen. Mr. Latour, redirect examination for this witness.
Yes, Your Honor. Thank you. Mr. Blitzer, I'll try to be fairly brief with you. In April, the first week of April, when you guys are going, when I say you guys, you and the defendant are going to Ocracoke Island.
Yes, sir.
Are you certain that you alerted him at that point, at least that point, that your wife, who was under his employment as the elected district attorney of his county, that she did not have any work from his county to perform?
Object to the leading, Your Honor.
Overruled as to the setting of the stage for the question. Go ahead.
I'm absolutely certain I alerted him to that fact.
Okay. And are you aware if after that point your wife continued to be employed by the defendant?
She was.
And are you aware if after that point,
Object to the leading, Your Honor.
Overruled.
if you're aware after that point, did your wife ever receive any work from the defendant?
Not to my knowledge.
Did your wife continue to receive payment during that period of time from the defendant's office?
From the state? Yes, sir.
Through that defendant's office?
Yes, sir.
And are you certain that at some point you had a telephone conversation or a conversation with the defendant about Debbie Hallbrook?
I am.
And during that conversation, are you aware if the defendant stated any reason why he fired Debbie Hallbrook?
He did.
What did he tell you?
He fired her because she was leaking the information about the investigation and Cindy's status to the SBI, or informing them of her status.
And he also told you about some other reason too, correct?
Yes.
And what was your impression about that? Was that reason discovery?
Purportedly, yes.
Okay. And what was your impression of that reason?
I didn't buy it.
And Mr. Blitzer, we've heard over the last day and several hours about some things that you certainly did that were wrong, correct?
We did.
And do you admit that you did things that you shouldn't have done?
Absolutely.
And in some way, did you try to make amends for that?
Every way I can.
And was one of those ways by entering into that guilty plea?
It was.
And was one of those ways by providing an affidavit in a civil case?
It was.
And to the best of your knowledge and recollection, have you been truthful with the jury?
I have.
Were you truthful with, to the best of your recollection and knowledge, to the SBI when you met with them?
Yes, sir.
Were you truthful in your affidavit, to the best of your recollection and knowledge, when you provided that affidavit in the civil case?
I was.
May I approach, Your Honor?
Yes.
May we approach?
Yes. room just for a moment while I take this matter outside your presence. If you'll just leave your notepads and materials in the chair there. Thank you. My understanding, the state intends to seek admission of what's marked as State's Exhibit Number 4, which is a memorandum written by now retired Donald W. Stevens, who was on that date the senior resident Superior Court judge of 10th Judicial District, relating to his recommendation, a non-binding recommendation on a presiding judge, that Mr. Blitzer receive a prayer for judgment continued. So this was referenced in the cross-examination. And Mr. Latour, tell me the purpose you seek to introduce this.
Your Honor, as you mentioned, it was, well, to set the stage a little bit, I specifically avoided this document during my direct examination when I elicited information about this plea agreement. The defendant brought this memorandum to the light. He's raised the issue for the jury about its contents and why, how it was created and what the contents of it are. He's questioned the defendant or the witness about it and said that, are you aware of it? He said he had not seen it, but that he was aware of it. And then the defendant, I believe, even had it marked and was about to approach, and then decided not to do that and decided to question him about it in another form. He's brought up the conclusions of that memorandum about and made allegations about the contents of it by stating that there's an agreement between the state that the state would not oppose a PJC, which is not contained in that memorandum, and alleging or alluding to the jury that Mr. Blitzer, the defendant in that case, would receive a prayer for judgment for his testimony today. That's not what the document says. I think it's certainly the door has been opened by the defendant for that document to be introduced into evidence. My understanding is that it was initially or at some point a portion of the court file and therefore would be admissible. But he certainly raised issues for the jury that this is the document that can clarify those issues as he has characterized it to them. And so I think it's certainly, by bringing up and referencing portions of it, it should then, the entirety of it, then be admitted. And I think it's highly appropriate at this point for that to happen.
Just one clarification. You said that, my recollection from the testimony was that Mr. Blitzer had seen a copy of this, was not aware of the meetings, but that at some point he had been provided a copy of this memorandum. I don't know whether that's correct.
That is correct, Judge.
All right, that was my recollection of the testimony. All right, Mr. Bradsher.
Yes, first of all, I'd kind of like clarification on the record because Ms. Freeman has said on the record that the state's position was not to oppose a PJC. So I hear a different argument from Mr. Latour that somehow that's not true. And I know that that is not in the plea transcript, although...
All right, well, that's an issue for another time. We're talking about the admissibility of this document right now. So,
well, Your Honor, I believe it is hearsay. My recollection was, as I asked him about the meeting and the memo, he did not recall it. And perhaps at some point further down the road, he said he remembered seeing it. I don't recall that, but I'm not going to argue with Your Honor about that. But I asked him and tried to get information about, because I think it's relevant to his testimony on whether his expectation is to get a PJC. But all the specific lines in that memo, especially a conclusion from Judge Stevens in evaluating the affidavit, it's not only hearsay that's not it's not like a plea transcript. It's probably why plea transcript's supposed to have everything in it, so that it's not subject to this kind of issue. Here we have a letter from a judge who's retired setting forth all of these observations and recommendations that are non-binding and opinions that are not subject to cross-examination. There's a declarant piece of paper that the defendant cannot cross-examine. I agree that points raised in the document within the rules of evidence can be redirected by the state, but to introduce the whole document with the signature of Judge Stevens making observations like his opinion of the affidavit are clearly hearsay, and they are in violation of the Confrontation Clause, I would contend. And in addition to that, if you weigh in on more prejudicial than probative, I will not object to reasonable redirect on the terms within the document to the extent that I raised it up. But I do object to the full document being offered without the defendant's ability to cross-examine the declarant.
Well, I think it is accurate that without objection, you elicited on cross-examination that there was a memorandum from Judge Stevens that recommended a prayer for judgment continued. I mean, you acknowledge that that was done.
Yes, and to the extent that it's relevant, it's what is in this witness's mind as to the effect that it would be impeachable, that he is testifying in anticipation of the possibility of getting a PJC, which he has clearly said that it is a possibility. That's why I raised the issue about the state's consent or not, because there appears to be a factual distinction, because that also bears on state of mind of the witness and this potential PJC. He has gone further to say he hopes for more relief from that on a conditional discharge. So basically, this is also character evidence offered by the state to enhance the credibility of this witness from a retired judge, specifically regarding an affidavit that has been introduced in evidence.
Well, that is a concern. There are a number of opinions expressed here of mitigation of Judge Stevens. And what I do think is admissible to corroborate or rehabilitate the effort to impeach this witness with some agreement or understanding or anticipation of a PJC and how that came to be is that this document does reflect that a meeting occurred with Judge Stevens on or that a plea was entered on a certain date, that Judge Stevens was the presiding judge, that when the defendant entered his guilty plea, it reflects who was present at the meeting in chambers. It reflects that, which is consistent with Mr. Blitzer's testimony, that he was not present. It reflects that it was anticipated that the investigation would be concluded and that the case is still pending. It reflects that Judge Stevens is retiring. And that in his view, in view of the cooperation of Craig Blitzer, as described in this order, I will by letter recommend to the sentencing judge judgment be continued upon payment of costs, and this is conditioned upon Mr. Blitzer's continued truthful cooperation, and that it's not binding. All of those things, I think, would be consistent with things that were largely elicited during cross-examination. And so I would permit the introduction of this memorandum for that purpose, to corroborate those things. But as far as the findings by Judge Stevens, enumerated 1 through 10, I would exclude those for the time being.
May I be heard about that?
Yes.
I understand Your Honor's ruling. My only argument against that would be that those findings by Judge Stevens would be, I would submit, tantamount to essentially a judicial order that he has found those things, not just opinion. Those would be his findings in that case, and therefore would not be here. Or they may be hearsay, but would be admissible in this case. It's different. The other thing that I would submit to Your Honor is that by introducing just that last sentence of conclusion, it by necessity references those findings. And so without them, there is no context as to that finding, and it creates a question in the mind of the juror potentially as to, well, what are these findings that are going on, and why is it? The whole issue that the defendant is raising on cross-examination is that you might get a PJC for this. You don't have to do anything to get that other than by pleading guilty. That's not the case, and that's not why he might get the PJC. The judicial order or findings of fact in this case would be those orders or those findings of fact that are enumerated within that document.
Well, they're not findings. They are, at the meeting, he was advised of these things. So he enumerates them.
But he does mention in there his impression where he says he does find that the affidavit was credible, and he does find that he is truly remorseful. So these are not things that were presented. I have no problem redacting whatever has been presented and then presenting that to the jury, but I think the things that he says he is finding should be admissible.
I'm not satisfied that the probative value of this outweighs the potential prejudice, undue prejudice of having a former Superior Court judge make findings about the veracity of affidavits and things of that sort. I have no doubt that is the basis of this recommendation, but this was not an adversarial proceeding where Mr. Bradsher had an opportunity to be there. It's language. It's difficult to say what what Judge Stevens was advised of versus things that he specifically finds. It states impressions, certainly favorable impressions. The court has been so impressed with the defendant's cooperation attitude that the court has advised all counsel it would consider continuing judgment in this case at the time of sentencing. And perhaps that may be the only conclusion that would be needed to place things in context. Well, I think that may be appropriate then. There are 10 enumerated points that Judge Stevens makes, and I think that nine and 10 describe the context of why Judge Stevens entered this order, or not this order, but wrote this memorandum that he says in 9, prior to the entry of defendant's guilty plea. So the guilty plea occurred July 17, and this memo is dated October 27, 4 days before Judge Stevens retired. It says, prior to the entry of defendant's guilty plea, the state and defendant's attorney requested the court continue sentencing to enable defendant to further assist in the investigation of these matters and to testify truthfully if called upon to do so, to further mitigate the damage his conduct has caused to the state and others affected. The court granted that request. This is paragraph 10. The court has been so impressed with defendant's cooperation and attitude that the court has advised all counsel it would consider continuing judgment in this case at the time of sentencing, if the defendant has complied fully with his obligations to provide truthful information and truthful testimony in all matters, civil and criminal, pending in the Superior Court of Wake County and the North Carolina State Bar. And then he goes on to say why circumstances were that he felt he needed to write this letter now in light of his pending retirement, and that this recommendation would be non-binding. I do think that those two paragraphs, what I would exclude are paragraphs 1 through 8.
Yes, Your Honor.
May I be heard on 10, Your Honor?
Yes.
As the courts pointed out, this document was the fruit of an in-chambers conference where the state by the DA and this defendant's attorney were present. It wasn't an open court formal judicial proceeding. I understand where the court's going, and I don't object except for this number 10, because again, the opinion of the judge to say, I have been so impressed with that type of editorialism will have an impact on the jury, and I will not be able to cross-examine that, where I would bring out, obviously, I will be arguing not just at the end of this cross-examination, but after all the evidence is in, that there hasn't been truthful compliance with this agreement. For the jury to hear there was a conclusion from a judge based on representations in chambers by the defendant's attorney and make this observation of so impressed with, that's an opinion that I believe is prejudicial to the defendant. It adds character evidence for this witness, and I'm unable to cross-examine that. However, to the extent that sentence 10 could be redacted or modified in some way, I certainly think it's appropriate to say, because the matters were not completed, that based on what this court has seen, the judge was inclined to grant the PJC conditioned on cooperation. But so impressed with, I believe, crosses the line.
And I'll just note, as a point of clarity, this memorandum does not refer to a meeting in chambers that resulted in this memorandum. Maybe that happened, I don't know, but this memorandum refers only to a meeting in chambers prior to the guilty plea on July 17. So I don't know what led, and maybe there's other testimony that you'll remind me of, but I'm just saying that from the face of it, I don't know what, from the face of this document, I don't know what led to Judge Stevens doing it, other than it's 4 days before his retirement.
Yes, Your Honor. I would just clarify for the record, because a lot of it's filed in the court file. based on the testimony of Ms. Freeman as well as multiple emails confirm.
Okay, that's fine.
I wouldn't argue it if it wasn't what the information the
Right,
state's given.
I thought that might be the case, but I just want to make sure that there's nothing in the face of this document that references that meeting. All right. And the problem I'm having, Mr. Bradsher, is that I think from the testimony or from the questions that were asked of this witness, the inference that you were seeking to draw is that Mr. Blitzer had some unwritten expectation at the time of his plea or thereafter that he would receive a PJC. And what this memorandum, I think out of fairness to the state, seems to reflect is that Judge Stevens, at the time of sentencing, left sentencing open for the most part, but that he later, immediately prior to his retirement, felt he was in a position to say, now that time has passed, and for reasons 1 through 8, I am satisfied that that's occurred. And at this point, in Judge Stevens' mind, he was so impressed with defendant's cooperation and attitude that he was in a position to say, I would recommend, in a non-binding fashion, upon the sentencing judge, that a PJC be offered. So it does set... it does go directly to the, in my view, it corroborates the state's position, and to the extent that the state is saying Mr. Blitzer had no agreement for a PJC, that would be up to the judge, and that here we have the judge making a conclusion that at least at the end of October, he was of mind that a PJC would be appropriate.
Your Honor, I contend that happened before the plea, and I have evidence to show it, that both the state said they would not oppose to the PJC, and the state met with the defense lawyer with Judge Stevens before the entry of the plea, and that they had already discussed that eventuality if he did those 3 things, and which is also included, I don't know if it's in that memo, cooperation with the criminal prosecution, the state bar, and the civil action. And that was specifically discussed in chambers, which is,
All right.
again, Your Honor, problematic to the defendant because we're not there. and there is no way I can cross-examine the impressions of Judge Stevens based on the information he was given.
Okay. I'm going to write on this copy, which is marked as exhibit number 4.
Yes, Your Honor.
So I'm going to redact paragraphs 1 through 5, numbered paragraphs 1 through 5, and paragraphs 6 through 8. Those are on page 2. I'm going to redact in paragraph 10, in the second sentence, paragraph 10, it says, the court. I'm going to redact the words starting with has and go to the word court so that it will read, the court has advised all counsel it would consider continuing judgment if defendant has complied fully.
No objection to that redaction, Your Honor.
Yeah. So that's what would be admitted if you choose to admit exhibit number 4.
To that end, then, Your Honor, what I would seek to do at that point, I guess, is introduce it, have him read those sections that are admissible and not publish, so that we don't have to go through and redact everything as far as
Yes, sir.
copies for the jury.
Yes, sir, I understand.
Okay.
All right, that's how we'll do it then. All right, very good. Do you want to collect your exhibit number
By my
4?
approach.
And if this is the one you want to hand to Mr. Blitzer, I think it's probably clear what is redacted. And I do not, I think that it is appropriate to say that there were paragraphs 1 through 8 that, and I can instruct that the court has redacted them because they're not relevant to these proceedings, or that they're not appropriate for the jury to consider, some language to that extent. But so that you can certainly reference that there are a number of findings or a number of itemized paragraphs that Judge Stevens referenced, and then we would allow the remainder that's not redacted to be read to the jury.
Yes, Your Honor.
All right. Very good. Let's bring jurors in. All right, ladies and gentlemen, thank you again for your patience. And again, please don't speculate or concern yourself about what happens during your absence. Mr. Latour, further redirect examination?
Yes, Your Honor, if I may approach.
Yes.
We're showing you what has been marked for identification purposes as State's Exhibit number 4. If you'll take a moment, review that document, and after you've done so, if you'll let me know if you recognize what it is.
I do recognize it.
Okay, what do you recognize that to be?
It's a memorandum from Judge Stevens, who took my plea.
Is that the memorandum that you talked about with the defendant during his examination of you that Judge Stevens had created that talked about a possible sentence for you?
Yes, sir, it is.
Okay. And does it appear to be fair and accurate in your opinion as to the contents of it as you remember them?
Yes, sir, it does.
All right. And other than some redaction, does it appear to have been altered in any way?
No, sir.
This time, Your Honor, the State would move to introduce State's Exhibit number 4.
No objection.
All right, and as redacted, it's admitted.
Thank you.
And members of the jury, I've ordered certain portions of this memorandum to be redacted because they're either not appropriate or not relevant for the jurors to consider in this case.
Thank you, Your Honor. Now, starting with the first full paragraph there that begins, "The defendant entered," will you read that to the jury?
Yes, sir. The defendant entered a plea of guilty on July 17th, 2017 to the Class 1 misdemeanor of failing to carry out a duty of his office as district attorney.
And be sure to read slowly so the
Yes,
court
sir.
reporter can keep up.
Good. In violation of North Carolina General Statute, Section 14-230, reading verbatim, I was the presiding judge that accepted this guilty plea.
And the second paragraph full there?
Prior to this guilty plea hearing, I met in my chambers with District Attorney Lauren Freeman and defense attorneys Michael Grace and Christopher Clifton. Such a meeting is appropriate and authorized by the rules of this court.
Now, in that paragraph, it does not mention your name. Is that as you testified earlier because you were not in that meeting?
Correct, I was not at that meeting.
Now, moving on from there, there's a... May I approach again?
Yes.
So the second page, paragraph 9. Can you read paragraph 9 for us?
Prior to the entry of defendant's guilty plea, the state and defendant's attorneys requested that the court continue sentencing to enable the defendant to further assist in the investigation in these matters and to testify truthfully if called upon to do so to further mitigate the damage his conduct caused to the state and to others affected.
Now, in paragraph 10, can you read the appropriate portions of that paragraph for us?
The court granted that request. The court has advised all counsel it would consider continuing judgment in this case at the time of sentencing if the defendant has complied fully with his obligation to provide truthful information and truthful testimony in all matters, civil and criminal, pending in the Superior Court of Wake County and the North Carolina State Bar.
And can you read on from there?
To the conclusion?
Yes.
Yes, sir. When the defendant entered his guilty plea, it was anticipated that the investigation would be concluded and the matter of Wallace Bradsher would have been resolved. That case is still pending. I, Judge Stevens, will retire on October 31st, 2017, and will not be available to consider the issue of entry of judgment in the matter of this defendant. However, in view of the cooperation of Craig Blitzer, as described in this order, I will by letter recommend to the sentencing judge that judgment be continued upon payment of court costs. This recommendation is conditioned upon Craig Blitzer's continued truthful cooperation. This recommendation is not binding on the presiding judge and does not restrict the district attorney's right to request a harsher sanction. Sincerely, Donald W. Stevens.
All right, thank you. Now, in reading those sections of this document, it would appear that all of this is contingent upon you telling the truth.
Yes, sir, it is correct.
And as you testified earlier, is that what you've done here today?
To the best of my ability, yes, sir.
And the last several days?
Yes, sir.
You also indicated that last sentence that this is non-binding upon the presiding judge and does not restrict the district attorney's right to ask for a harsher sanction.
Yes, sir.
Is that your understanding of what this plea agreement was?
Yes, sir. It's what we've discussed as an open plea where my lawyers can argue for something better than the prayer for judgment and the state can argue for a conviction on the other side.
All right, thank you. Your Honor, at this time, I think it's already been published, but I would ask that Defendant's Exhibit Number 10 be published again to the jury. I believe they still have their copies, and that if they have not taken a moment to fully read that document, that they read that document in its entirety and allow us to know when they're done.
All right, very good. So members of the jury, you have in front of you, continue to have Defense Exhibit Number 10, which is a multi-page affidavit. If you would just take some time to read that, and again, when you're finished, just set it down and look up so that I can tell that you finished. Further questions? And ladies and gentlemen, I'll just say, with respect to evidence that's been admitted, again, in the concluding instructions I give you prior to deliberations, I'll explain to you a process by which it's possible for you to request or review evidence if you need to. So that request will be in my discretion. But I just wanted to bring that to your attention so that in the event that you feel rushed in reading documents, that there is a possibility that you could see them again. All right, Mr. Latour, questions?
No, Your Honor.
All right, Mr. Bradsher, questions on recross?
Just briefly, Your Honor. Mr. Blitzer, you and I took the same oath, didn't we, for district attorney?
Well, yours was 9A, mine was 17A, but yes.
Had the same responsibilities to the law and the Constitution, is that right?
Correct.
And based on the deal that's just been read for the jury, it's a condition that you tell the truth in all these matters, is that right?
Correct.
And in the affidavit that the jury has just read, there are a lot of allegations, aren't there?
I guess.
Okay. And you specifically say in paragraph 14 that you instructed your lawyer, Michael Grace, to meet with my staff to reassure them that they should cooperate with the SBI and tell the truth. Is that right?
I don't have it. If that's what it says in 14, that's what it says.
But yet, during the fall of 2016, as the interviews begin, you have a young lawyer, Spencer Morrow, who's just graduated from law school, right?
I think he would have graduated before that, but certainly a young lawyer, yes.
And Keeney, your right-hand man, comes to you, and y'all have a meeting. And Spencer Morrow has been one of the people that assisted with the classes at the office, right?
No, I keep telling you, I think Spencer just assisted with a placement exam, not a class.
And isn't it true that you're aware Spencer Morrow's concerned about the SBI interview because of this class situation? Keeney told you that, didn't he?
Well, you're asking me what,
Sustained as to what someone else said.
In the meeting with Keeney, you knew Spencer Morrow was concerned about that, right?
what meeting with Keeney and when?
In the fall of 2016 during the SBI interviews.
When I was in BLET in the fall of 2016, and don't remember ever having a meeting with Keeney.
Isn't it true you directed Keeney to tell Morrow to keep his effing mouth shut?
Objection asked and answered.
Your Honor, I'd like a little latitude. I only have 2 or 3 questions left.
All right, go ahead, sir.
Isn't it true that you told Keeney to tell Morrow to keep his effing mouth shut?
That is not true.
So you dispute that fact, right? Here under
That's why
oath?
it's not true.
Okay. And when I questioned you about that, you said some disparaging things about Keeney, right? Like
You
trust
asked me
account
what?
issues, lawyer issues. Is that right?
What's the question?
When I questioned you about that, you disparaged Mr. Keeney and said he had trust account issues.
No, you asked me why I thought he would make that up or
Okay.
say something like that. I didn't cast any disparaging remarks.
All right. So you believe that Keeney made that up?
You asked me if I said it, the answer is no.
Okay. You also, in defense of that, said, well, when the SBI come knocking, it doesn't take much motivation to say whatever it takes, right?
That's correct.
And as a sworn elected DA, when the SBI came to you in September of 2016, you referred them to your lawyer and wouldn't speak with them until May of 2017. Is that right?
Correct.
And that is the first time this set of facts been put out that led to the affidavit a month later that the jury just read. Isn't that right?
What facts?
The facts you set forth in the affidavit and the SBI.
If you're asking me that the first meeting with Agent Whitley took place in May of 2017, yes.
And then we started out today with the text that we just received from Mr. Keeney. WTF. When you heard Shireen was telling everybody they needed to meet with Whitley. You do admit that, don't you?
Sure.
So as this process continues and evidence comes out to address the things you've alleged in these statements, you still assert to this jury that they are true.
They are true, to the best of my recollection.
Thank you very much. Nothing further.
Thank you, sir. You may step down.
Thank you.
All right, ladies and gentlemen, we're going to go ahead and take our lunch recess now before we move on with further evidence. And we'll need to go ahead and resume at 2:30. There's another matter unrelated to this I need to attend to across the street. So we'll resume at 2:30. Please leave all the materials at your chairs. The bailiff will pick up the evidentiary items that are at your desk there during the lunch recess, or at your chairs during the lunch recess. Please recall all the rules and instructions I've given you. Again, leave materials in your chairs, gather in the deliberation room at 2:30. Everyone else, please remain seated.